Good morning, everyone. In Business Law 2, we're going to go over Chapter 30 today briefly, I hope. I'll try to keep it as modest as possible. I think I posted a couple of YouTube videos from other educational entities or schools that I think capture the material about partnerships much better than any way I ever could. But I thought I'd put my thoughts up there nonetheless. Partnerships aren't nearly as big as sole proprietorships. They're the biggest form of business organization in the country today. However, partnerships are nonetheless very important, especially the ramifications for partnerships, meaning the liabilities and risks related to general partnerships. We'll talk about limited liability partnerships a little bit later. We already mentioned, I know, in the previous chapter when we introduced business organizations. But partnerships are very important. They're very significant, especially in my realm. I'm a practicing lawyer, and many lawyers, in order to pool talent and to pool money, pool resources, and to gain sort of a unified front in the business world of being practicing attorneys, partnerships are often seen as very, very popular, but there are major risks involved with them. So in order to have a partnership, you don't have to have a writing. Many people think it has to be by written form. It can be oral, it can be in writing, and writing is preferred, and I'll get to the reasons why in a moment, but it also can be implied, which is very, very dangerous. People think, oh, I'm not in a partnership. You don't even necessarily want to be in a partnership, but you might well be in terms of what third parties perceive you as doing, you and another or multiple people being involved in the engagement of some kind of business, and it has to be for profit. That's also one of the distinguishing factors between that and other organizations. Partnerships must be for profit. You can't have a nonprofit partnership. You can have a nonprofit corporation, but you can't have a nonprofit partnership. It defeats the entire concept of partnership identification. So whenever you see a nonprofit organization, I almost can guarantee you it's some other entity other than a partnership. So it can be done orally. Two people can just get together and say, hey, let's start a business. This is actually fairly common in the law practice. I've been in one myself where you're working occasionally on some matters that seem to overlap with some other attorneys. You become friendlies, or maybe they're friends from law school, and you're kind of dissatisfied with working at a law firm under sort of the management and control of other people, and you feel like you know enough and you learn enough and you want to start off on your own, but it's daunting doing it completely alone to be a solo practitioner. So maybe you and a few friends want to get together and start a law firm. And maybe your specialty wasn't business organizations. You're, I don't know, malpractice attorneys doing medical malpractice, or your tort attorneys, or your criminal defense attorneys. And so you just decide, let's all pool our money. Let's all come up with X number of dollars. We'll rent a nice office space. We each all have our own individual office, but to be a suite where a paralegal can work, and maybe a secretary or receptionist. We'll have a library and a conference room, and we'll go out and do business. We'll have business cards made up with all of our names on it. We'll create a firm name, and we'll put one centralized phone number, and then we'll have individual lines that we can put on our business cards and on the letterhead and things like that. We're now a partnership. We don't have a written formal agreement of how profits will be distributed, how costs will be incurred, how decisions in management will be made. So how does that get determined? Well, the law basically presumes that if there's not a written contract to the contrary, all obligations, debts, are shared equally, all profits are shared equally, and the management can be done by any member of the partnership. So one day I might come in and someone decides to have a whole, a new staff member come in to do our books, for example. We hire an accountant, and I didn't like that. Could I still be bound to that contract? Yes. Individual partners have the ability to bind all of the partners as long as it's in the course of scope of the business and it's in furtherance of the business interest. That's why I always advise people that no matter how close you are, family, friends, loved ones, people you've been with forever, it's always a good idea to have a written partnership, because then you can spell out how decisions that'll be made, maybe over a certain cost dollar, maybe it'll be about personnel, maybe about renting space, purchases, all of those things could be spelled out. Which partners might be able to make the decision, or if it has to be multiple partners, is it just a simple majority, or is it a supermajority for certain kinds of behaviors? And so those are the kinds of things that you become very, very attuned to very rapidly, even though you're very close friends and family members, that if you don't have a written, spelled out, express agreement as to what the partners' duties and obligations are, it can really, really get derailed quite rapidly. And so we'll talk about the implied ones in a second. So in a written agreement, and I know one of the first times I was working in a law office, I worked for a general law firm, did everything at the law firm. And because I was a new guy in there, they kind of gave me a jack of all trades sort of approach. So one time somebody came in, a couple of people, and they wanted to come up with a formal partnership. And I'm like, great. I knew the theories behind it, but I never written one up before. And so the good news is, especially now with the internet, when I first started, the internet wasn't, it was just in its, you know, origin era, if you will. But now through not only printed materials, they had printed materials then, I wasn't aware of it, I became aware of it pretty quickly, but there are model partnership agreements out there for almost any kind of business one can imagine. And so you don't reinvent the wheel. You find models, templates, forms that have worked in the past. Massachusetts Continuing Legal Education has excellent um, partnerships agreements that can be modified and or massaged to your client's needs. Also, there is called Mass Practice, and there are many, many authors of form books. They're called form books or practice manual books that help you write these things if you're new and not accustomed to them. It's always good to work for an experienced attorney that has done some partnership agreements, but they do things like the date of the inception of the partnership, the name of the partners, the nature and duration of the business, name and location of the business, individual contributions by partners. Why? Why do you want to know that? Why do you need to know that Jim dumped $50,000 into it? Because either upon dissolution or when profits are starting to be made, I might have the ability to get first cut for the contributions I made above and beyond the others. Otherwise, it'd be equally. So if we all dumped in 50,000, we'd equally be just repay back our contributions. But what if no one else? They just brought their talent. I brought the money. We should have not only that acknowledged in the partnership agreement initially, but the method and the means and the timing by which I might be paid back that money and whether there's any interest in it. Sharing of profits, losses, and responsibilities. That's a huge one. If we don't put that in a written agreement, and if it's either oral or it's not stated, profits, losses, and responsibilities fall equally upon all partners. And you got to be careful about that one. Maybe we have a partner that's great at tax law. We really love to have him in the firm because he's or she's doing a fantastic job in our tax consulting wing of the law firm. But what if they're just a terrible management in terms of the people they hire and the office supplies they buy? We don't want them buying that stuff. They're going to buy all kinds of wacky stuff, and it would really set us back. So we have to keep that consideration in mind as well. And why most people say, well, we want profits shared equally. That's not necessarily the case. What if there was 4 of us and one of us was just out there doing a lot of great work? They bring in a ton of clients. We might want to have some kind of hybrid method by which we distribute profits. Maybe the first 50% of all profits are shared equally, but the next tier of profits are shared based upon maybe closing cases or where the money came from. So there'd be some incentive to bring in clients. You can do all kinds of very creative profit sharing schemes, if you will, within a partnership. Junior partners, senior partners, you can have all these different levels in terms of how much of a cut they can get or want them to get. Keeping of accounts, who's going to do that? Duties of the partners. Duties of the partners are always implied by law because the relationship is special. Just like principal and agent from the previous chapter, partners owe a fiduciary duty of the utmost loyalty to the other partners and to the interests of the partnership. This actually I keep using law as an example because that's my personal experience. But think about it. I'm a lawyer. I'm working in a law firm. I got my partners, and all of a sudden, a big personal injury case from my family, one of my relatives gets in a very bad car accident. It's not their fault. Looks like it might be a very, very lucrative case in the end, not only for the client. Well, it's not really lucrative because they've been injured and they're only being made whole, but maybe the firm's going to make a lot of money. Well, you know what? Maybe I'll just work that on the side on my own time on Saturdays, time off when I'm not working for the partnership. So I'll keep it on the side. Can't do that. You have to share and always work for the partnership's interest. You can't keep things secret, and you can't have an interest divided to the loyalty of the partnership. Very, very important. That's the same as agency and principal. Amounts of withdrawals of money, usual restraints on the partners. Yeah, you can put restraints right in the part. Like this partner can't go and buy things for our law firm, or this partner can't do any hiring or firing because they're kind of wacky and they fire people willy nilly because they're in a bad mood, or they hire a bunch of new people that we don't necessarily need because hanging around the bar on Friday afternoon and they're feeling good and they want to award jobs to their friends. And then the provisions for dissolution. How will we dissolve the partnership? If there's nothing in there, there are mechanisms in the law or to control how partnerships dissolve and signatures of the partners. Now, the implied agreement's a little bit more troublesome because this happens often by mistake. And I think it happened to me, and we never had any issue with it. But I worked with 6 other attorneys. We were all solo practitioners. Uh, there were, I think, 8 offices in the building. Eventually, I got lucky enough to buy the building on some very, very good terms. So these guys, they're all friends of mine. They're renting from me, but we started sharing things like a high grade copier. We shared a fax line. We eventually shared some staff. We hired a paralegal and a receptionist, and we all shared them. And we had multiple phone lines come in, and the receptionist would know how to distribute the calls based upon who the client was looking for, and we shared a lot of overhead and a lot of expenses, and we had a bit of an advertising campaign that kind of shared expenses. To the public, I think we looked very much like a partnership. There was one entry into the building that opened up into the suites, and on that front door, we had that beveled type glass, that frosted glass with the gold lettering of all of our names. It sounded like we were what? To a reasonable person that came in the firm. It looked very well like we were affiliated. And therefore, if one of the other partners committed malpractice or got sued or incurred debt, could those creditors or the people that were had a cause of action against that one individual, could they sue the other people as an implied partnership? Partnership by estoppel is called. Yeah, they could. You got to be very cautious. And occasionally, when you go into a medical office or into a law office, sometimes you'll see a sign saying the doctors here are not affiliated with such and such. They are all individual licensed practitioners of their own accord, or something like that. What they're trying to do is avoid the perception that the public could possibly adopt that there's a partnership going on there, because one doctor doesn't want to be liable for the other doctor's costs, expenses, and liabilities. It says partnership by the partnership name. You don't have to have a name. It is a good idea to have one, sometimes called a DBA, doing business as. In some states and jurisdictions, I don't know if Massachusetts requires it, but it's called the fictitious name statute, because you want to have people to be able to say, hey, I just went to called the Worcester. I always wanted the name of this because I think people think it's going to be a lot cheaper. The Worcester Law Clinic. I don't know, clinic always assumes it's either going to be free or very cheap, and we're doing it for the nobility of the law. And so they came in, but we're really a partnership. Shouldn't we have that name registered with the Secretary of State's office, and then the list of partnerships that are actually the behind the scenes owners of it, so that way if there is liability or damages or a need to sue us, they can sue it as the Worcester Law Clinic. They can sue in the partnership name, but they could also sue us individually as partners. And you'll often see that. You'll say, John Jones versus the Worcester Law Clinic, or Jim Corman, John Doe, Mike Coughlin, Mike Osowski, DB, doing business as the Worcester Law Clinic. You sue it in both entities' names because they are basically a reflection of one of the other. Tenancy and partnership. There's no such thing as a tenancy and well, there is, I should say. Partnerships can own property. They can own real estate, they can own objects, and they can own the goodwill of the entity. When they die, the heirs don't become a partner. They just simply become owners of that partner's interests. They receive the profits, and upon dissolution, they receive the equitable share minus any costs or debts that were owed by that partner. And unless there's a written agreement to the contrary, a death of any one partner or with the withdrawing of any one partner, the partnership ceases. Many of the remaining partners will just simply start up a new partnership immediately in the moment. But it's better to have a tool by which succession can occur and the partnership doesn't dissolve simply because one partner wants to retire or withdraw and go do something different, or unfortunately pass away. Duties of partners, that's very, very important. Duty to exercise loyalty and good faith. Sounds very simple, but you'd be surprised how people try to do self-dealing on things related to it. And I know realtors that have done that. There's realtor partnerships, and all of a sudden, I'm going to show my sister's house. Such. Well, geez, I didn't see that in our listing. It was, oh no, I'm doing it on my own. What do you mean doing it on your own? We're a real estate agency that are partners, and you can't do side deals like that without the consent of the other partners. So it doesn't sound like it's disloyal because you're doing it for family or friends or something, but it is, because you have to think of each other as one, and it's a hard mentality to maintain in all circumstances. Duty to work for the partnership. That's the other thing too. What if I have, for example, I teach full time at the Mount, and I've taught at some other places part time, but I also have a law practice. I'm not in partnership with anybody. I have a friend of mine who is getting into teaching part-time for a few institutions, and he has a partner, and sometimes he teaches day classes during the day, and he leaves the office and goes and teaches them. There's some tension there with his partner, although they've been partners for over 30 years, that, hey, where's your duty to work for the partnership when you're out there teaching at Worcester State or Quinsigamond Community College or Mount Wachusett Community College. There's some tension there because that's just it. When you have a partnership, you can't have divided loyalties, even if it's not related to necessarily what the partnership's about. Duty to abide by majority vote, and that's a bitter pill to take. Like when I was in a partnership early on, there was 5 of us, and occasionally 3 people would vote on something that I thought was, and I'm sure I was part of the majority sometimes voting for something. I still remember buying a very, very expensive in the day, 1993 or 4, buying this floppy disk things for a software program just to help us bill our clients. I didn't know what was so hard about we had typewriters back then, just typing up, you owe us, $450 for 3 hours of legal services on this date and time. But the program supposedly did it for us, and it cost us a fortune at the time. And I was really upset about it because we didn't have that many clients. We didn't have many bills to issue. They weren't spending money on stuff like that. But that's the difficulty of being in a partnership. You might be overruled because you're in the minority view. And secondly, maybe some of those decisions should have been given to a managing partner to avoid some of those controversies. And duty to inform. That's the thing. Always, hey, I got a really good deal here. I'm going to keep it to myself, or I'm going to give it to my sister. I'm not going to give it to the partnership. That happens a lot. Don't do it. It's illegal, and you could be sued for damages by the remaining partners. You could be expelled from the partnership. I think that covers most of this. Work with the partnership. Rights of the partners, right to participate in management. That's scary. We might have one, like I said, we have this tax woman who's fantastic at taxes. She brings a lot of clients for her. We love her, but she's kind of an oddball. We don't want her hiring people. We don't want her making decisions about how the office will be set up and the culture of the office. And she's doing all kinds of wacky stuff. And she has that ability to do so, though. She's an equal partner, and equal partners have just as much say in running the daily affairs of the office, unless you did what? Had a business agreement saying otherwise. So they have the ability to participate in management. The right to inspect the books. I think that's common sense. Hey, I want to see what's coming in and what's going out and where it's going, because it doesn't seem like we have that much left at the end of the month. And we used to do a monthly thing at our law firm. We used to distribute, we had X number of dollars go out, we have X dollars come in, let's distribute the funds. But there are other times you might want to take a peek at the book. You have absolute right to do so. You can't be denied that. A right to contribution. That's like, okay, we had say we owned our building, we all owned it together, and there was a broken pipe and the plumber had to come out right away, and it was a $1,500 cost. I paid them out of my personal funds. And say I had 2 other partners. Can I expect to get $500 from the other 2 partners in contribution for that debt? Yeah, as long as it's in the course and scope of the partnership and for furtherance of the partnership's interests. Pretty common sense. And right to withdraw profits. That doesn't mean you have a right to withdraw profits daily. And so that's another reason why you want a writ agreement. When will partnership profits be distributed? And there's some debate, well, maybe we shouldn't distribute all the profits this month. Maybe we should put a little bit of that profit margin into further advertising or into further continuing legal education, whatever it is your business is. So I always think landscaping for some reason, because my father's dead now, but he used to always brag about this kid I grew up with who started mowing lawns at 16 or 17 and ended up becoming a very, very wealthy, successful, had a chain of regional landscaping companies and did very, very well and things like that. So when profits come in and you have partners, is it always about just distributing property, or what about getting some more pickup trucks or some more, ride-on lawnmowers to enhance our enhance our abilities to expand? Those kinds of things need to be settled by you. If it's not spelled out, it's by majority vote. But if it's not done by majority vote, you want a mechanism by which you're going to do that. Withdrawal profits. Okay. Liabilities of partners. This is the big one. Liabilities for contracts, liability for torts. Be careful. Liability for crimes. Look at that in a second. But think about it. If something is done in the course and scope of the partnership, you're liable not only for what you've contributed to the partnership and what's owned by the partnership, you're liable personally. So what if 2 of the lawyers that I'm working with, they don't have any personal assets? They're younger than I am, for example, meaning they just got out of law school recently. They have a lot of law school debt. They don't have any real assets, but boy, they're real. I don't even know what to use the term crackerjack anymore, but they're just really dynamic attorneys. And I meet them at some seminar, and we hit it off. Let's open a law firm. I'll do the criminal defense. You do divorce and family law. They don't want to do the personal injury stuff. Kind of a, broad-based law firm now. And all of a sudden, there's a big lawsuit against us. because of what one of on a med mal case, we get sued for $500,000. Am I liable because the med mal attorney that we have in our office screwed up? Yeah, if we're partners, I'm liable. I'm not only liable for what the partnership owns, but I'm liable for my personal asset. Well, aren't the co-partners as well? Yeah, but what if they're insolvent? They've got a lot of student debt. They don't own any homes or any property or anything like that. They're broke. So could I be responsible for the entire indebtedness of that tort? Yes. That's the danger of general partnerships. Very dangerous. Now, how can you get around it? Well, one is you don't become a partner, you become a limited liability company or corporation. The other way around it, I shouldn't say around it, but the protection against it is to have insurance. Insurance, I think, alleviates a lot of these problems. I'm surprised the book doesn't talk about it anymore, about the liability for contracts and torts. Well, contracts aren't going to protect you for insurance, but torts will. Torts, not long as it's not an intentional tort, negligence, things like that. You made a mistake in a case, you're going to get sued. You can have insurance for that. But contracts, we entered into a contract to rent a building for. I was looking at one recently, and I kind of backed out because I just thought if it's going to bring me any more money. I just liked it because it was a really nice office right across the street from the courthouse, and it just made me feel fancy or something being in there. But I was thinking about that. What if me and a partner rented it? It was going to be about $15,000 a year to rent this thing. It was a simple little place. I was going to rent it with another person. We'd probably be considered a partner because we're both lawyers. We both do the similar kind of work, and we're going to have like a one-letter head and kind of be a team. In the end, what if all of a sudden he walks away from it and said, we got a 3-year lease at $15,000 a year. It's a $45,000 of indebtedness. His wife got some coin. He's got some coin. He's saying, I'm retiring early. See you later, Jim. Well, he's liable on the contract just as I am, but if he's insolvent and difficult to chase, would I be liable for that whole contract? Yeah, and insurance won't protect you on paying contracts. Insurance is for negligence, accidents, things of that nature. Now, be careful about crimes. In order to be, I don't know what kind of crime one of my partners are going to commit that I'd be liable for. I don't know where a crime would be in the furtherance for the partner's interest. I don't know, one of the partners goes and kills a competitive lawyer. That's a crime. Certainly, I didn't motivate it. I didn't ask for it. I didn't want it. I'm not going to be liable for murder. However, if there's some kind of financial penalty against the partner's behavior, as long as the partner's behavior was in some kind of, even if oddball, furtherance of the partner's interest, the partnership assets and liabilities could come into play there. But it's very rare when it comes to crime. Usually, most crimes are specific intent. If I didn't have the specific intent to make it happen, my partner's criminal behaviors are likely going to be borne by him or her alone. Partnership liability or authority of a partner, sharing a profit law, pretty much went over that already. And customary implied authority. And this is what all partners in a general partnership usually have the authority to do, things like that, to compromise and release claims against a third party. Somebody owes the firm $15,000. They say, hey, Jim, we got $7,500 now. That's all we can pay, or we're going to go bankrupt and you'll get nothing. And I'll say, you know what, I think that's a wise move. Let's settle. Let's keep on good terms. You've been good to us before. You'll bring in more work in the future. We'll compromise that debt. And I do it alone. I don't even consult the other partners. That would be valid against a third party. I'd have to answer to my partners, and I might be liable potentially because I violated something in a partnership agreement. But that third party would be released because I had the power to do it as a partner. To receive payments and give receipts, that's common sense. To employ or discharge agents, that can be very controversial. One day you come in and say, hey, where's Deb? And the other partner says, I fired her. I couldn't stand her. So you want to have that spelled out in a partnership agreement, because if you didn't, any individual partner has the power to hire and fire agents. To draw and endorse checks, and that's one of the things we had in our law firm that we did have formally. I was the only one, not because I wanted it, but I didn't want the responsibility either. I was the only partner that was actually authorized to cut checks on behalf of the firm. And it became a nightmare later on. I wish everyone just stayed authorized, because I'd often not be in the office. I was in court a lot. It goes, hey, we got someone looking for a check down here. And I ended up having to leave, which is very dangerous, sign checks, or just tell them, sign my name to the check and fill it out to the creditor for whatever it was. But generally speaking, if we didn't put that agreement down, which we did, I wish we hadn't, any of the partners can sign any of the partnership checks that were going out. To insure the property of the partnership, to cancel insurance property, to buy goods on credit and to sell goods in a regular course of business. As long as it's a regular course of business, it can't be unusual. It's got to be for the furtherance of the partnership's interests. And sharing of profit and losses, that's the big one. It's very fast. It's kind of all over the place. Still 25 minutes, probably 20 minutes too long. I apologize. But I feel like I got to put these things up, and hopefully it helps fill in some of the, some of the general concepts a little bit better. Otherwise, be well.